Showing on this episode of Law Weekly highlights from the 6th Annual Conference of the Nigerian branch of the International Law Association as Senior Advocate of Nigeria, Professor Damilola Olawuyi, takes over as President of the ILA Nigerian branch. Also showing on the program, Justice Oluremi Oguntoyibo retires as a judge of the Federal High Court, laments disobedience of court orders, poor pay of judicial officers in her valedictory speech. Plus a recap of the top trending legal stories from the courts. Hello and welcome to the program. I'm Shola Shieli. Leading experts and stakeholders in international law have made a case for clear and comprehensive regulations to maximize the full value of modern technologies for the development of the economy and in a manner that respects and fulfills all international human rights. They made this recommendation at the 6th Annual Conference of the International Law Association Nigerian branch with the theme, The Role of International Law in the Regulation of New Technologies. The high point of the conference was the swearing-in of the new executives of the association under the leadership of the new president, Professor Damilola Olawuyi, Senior Advocate of Nigeria. Here are some of the highlights from that event.
The International Law Association, ILA, was founded in Brussels in 1873 under the leadership of a professor of international law, Professor Christine Chenkin. The association now has about 3,500 members in 45 national and regional branches around the world. The Nigerian branch is one of the young branches of the ILA. It was founded in 2014 with its pioneer president, King's Counsel and Senior Advocate of Nigeria, Professor Fidelis Odita. In line with the objectives of the ILA, the Nigerian branch provides an intellectual space for Nigerian scholars and practitioners to unearth, analyze, and resolve important questions in public and private international law, international diplomacy, and global governance. The 6th Annual Conference of the Nigerian branch of the ILA attracted several leading experts, stakeholders, and students of international law who all converged on the Lagos Court of Arbitration on Wednesday, the 19th of April. The hybrid event, which attracted over 300 participants, has the theme, The Role of International Law in the Regulation of New Technologies. The keynote speaker, Dr. Edward Kwankwa, the Assistant Director General, World Intellectual Property Organization, WIPO, Geneva, Switzerland, spoke about how countries and societies can harness modern technologies to advance sustainable development.
We all know for sure that the global economy is increasingly driven by innovation, and in this context, we see rapid advancements across diverse fields of technology. Not just new technologies. And these advancements are happening at an unprecedented pace. That's the most important thing to recognize. They are happening at an unprecedented pace and ending up giving the international community new challenges. But at the same time we are getting these new challenges, we are also having new opportunities.
He also emphasized the need for stakeholders in international law, including ILA Nigeria, to collaboratively build capacity to holistically address ethical, efficiency, regulatory, and other multidimensional questions posed by metaverse, big data, artificial intelligence, and other new technologies.
The multidimensional nature of these challenges that we are facing through these new technologies are such that it's clear we have to deal with them at a national level as well as at an international level. And by the same token, when it comes to international organizations, there is no way a single international organization can profess to be able to deal with new technologies in isolation of other international organizations. So whether you are WIPO or you are the International Telecommunications Union, you have to know you must operate in tandem with other similarly placed organizations, because it's quite clear the existing architecture of international organizations that we have today was definitely not designed to handle the multidimensional questions posed by new technologies. And whether it is through the protection of intellectual property rights, whether it is through the promotion of ethical and sustainable practices, whether it is through any other means, it's the international law that is essential. It's essential in ensuring that the international community as a whole shares the benefits of these new technologies, and this can only be for the common good. I would encourage all of you and you luminaries, whether legal or not, to understand that, speaking through the Nigerian branch of the International Law Association, the rest of the international community is eagerly looking up to you to see what suggestions you come up with. You are the ones who identify and use those new technologies. You are the ones who know what the international law says. You are the ones who know what the applicable regulations are. And maybe this is one area where we don't necessarily need to rush to try and regulate the technologies. Let's first try and understand those technologies. Because right now, if you talk to 10 different people and ask them about the metaverse, you may end up getting 10 different answers on what is meant by the metaverse. I suspect Google's understanding of the metaverse is very different from Yahoo's understanding of the metaverse. So it's up to us as scholars, as legal and non-legal luminaries, to try and help shape the understanding of that technology in order to be able effectively to condition or to regulate that technology.
The conference also featured a robust exchange of questions, ideas, and suggestions, a debate session between students, as well as panel discussions by leading practitioners on how multinational technology platforms can be effectively regulated.
It's an evolving situation. Co-regulation is the only possible option to deal with all these issues.
The high point of the conference was the swearing-in of the new executives of the association by the outgoing president. The new executives will serve under the leadership of the new president, Professor Damilola Olawiyi. Professor Olawiyi is an expert of energy and environmental law. He has practiced and taught law in Europe, North America, Asia, Africa, and the Middle East, and has authored several influential articles, books, and reports on the role of international law in extractive resource governance.
My first act as president of the branch is to announce that, effective immediately, we have established the Professor Fidelis Odito Prize in International Law. This prize will provide full sponsorship to one or more young members of the branch to attend the Global ILA conference, starting with the one that will be held in Paris, France this June.
While reacting to his emergence as president, Professor Olawiyi unveiled some of the new initiatives of his administration.
The Professor Fidelis Odito Prize is just one out of the many more initiatives that we will be announcing in the next few weeks. The new Executive Council is highly committed to propelling our branch to the desired next level of global impact. And like I always say, it is no accident at all that our country has produced 3 former judges of the International Court of Justice, several members of the International Law Commission, several UN independent experts, several executive heads of UN agencies. I think by what we plan to do is that we will continue to accentuate rigorous research, publications, training, and public dialogue, such that we will have another chance in this country to relive that proud history and produce the next Charles Onyema, the next Professor Teslim Elias, and the next Prince Bola Ajibola of blessed memory now, and of course the next Chief Bayo Ojo, a former Attorney General of the Federation and former member of the International Law Commission. International law has become so important with the challenges facing our world, whether you are talking about the problem of climate change, the invasion of Ukraine, water, energy, food poverty, the challenge of maximizing the value of intellectual property in a manner that fulfills international law, as we've been discussing today. We need more vibrant and talented Africans that we, like our guest speaker of today, Dr. Edward Kwakwa, who will dedicate themselves to propagating Africa's interests at the global stage.
The chairman of the Conference Planning Committee says the ideas and suggestions from this event will go a long way towards improving the work of the association.
So part of what we expect at the end of this event is to have a communique officially issued by the International Law Association Nigerian branch, as ILA Nigeria, that will include some of the thoughts from today going towards the regulators, especially because we expect that part of the themes that we expect from today is to hear about a lot of collaboration between the private sector and the public sector. And so I think having a communique that sort of embodies all of those thoughts together that the regulators can go back and draw on will be something very useful. So I would say that that's something to expect.
Away from that event, the Federal High Court has organized the Valedictory service for a judge of the court, Justice Oluremi Oguntoyibo, who is retiring from the bench after serving meritoriously. We have details up next. Justices of the appellate courts, judges of the federal high courts, judges from other state high courts and some retired justices gather here alongside senior advocates of Nigeria, other lawyers, family and friends to honor Justice Oluremi Oguntoyibo, who is retiring from the bench. This valedictory court session in honor of Justice Oguntoyibo is in line with the cherished tradition of the court to celebrate the exit of its judicial officer who retires with his or her record unblemished. The Chief Judge of the Federal High Court, Justice John Soho, who is the chief host at this event, says the early retirement of the valedictorian is a bittersweet event.
It is a cherished tradition of the Federal High Court to honor in style the exit of any of its judicial officers who retires with his or her record unblemished. Hence, we are here today to honor, celebrate, and bid judicial farewell from the bench of the Federal High Court and the Federal Judiciary to Honorable Justice Oluremi Omowumi Oguntoyibo, who voluntarily retired on the 31st day of October 2022 at the age of 64. Today's beautiful gathering is marked with mixed emotions of sadness and joy. Of sadness that Honorable Justice Oguntoyibo has retired, yet at the same time with real gratitude for her impressive contributions and the exemplary judicial service she provided to this court. I congratulate her on a job very well done. I'm elated because she has exited the court with her character and reputation spotless.
After the CJ, members of the bar also paid their tributes to the valedictorian.
Honorable Justice Oguntoyibo has been a trailblazer, breaking new ground in several areas of law and leaving an indelible mark on the legal landscape of Nigeria. Our retirement marks the end of a distinguished career in the judiciary, and it is fitting that we celebrate our remarkable achievements today. Throughout her career, Justice Oguntoyibo has been known for her impartiality, fairness, and fearless approach to the dispensation of justice. She has demonstrated a deep commitment to upholding the rule of law, protecting the rights of the vulnerable, and ensuring that justice is done in every case that comes before her.
They used the opportunity to reiterate some of the challenges facing the legal profession.
Nothing can be more pleasing to be part of the exit ceremony of an outstanding jurist. And having listened to the valedictory speech of the Chief Judge, it is clear that she came in here and she walked elegantly, confidently through the judicial. Let me state categorically that only the lawyers and the judges in active practice can consciously save the judiciary. As the son of a judge, I am alarmed, I am disappointed about the conditions of service of the judiciary. I'm calling on the senior advocates who are making tons of money through this system to know that we have to protect and enhance the judiciary if we will continue to have a forum for independent justice, confident justice, and make the judiciary attractive to the best of lawyers.
Justice Oguntoyinbo was born in 1958. She took an early retirement from the bench at the age of 64. Welcome back. Justice Oguntoyinbo has been speaking about some of her regrets while on the bench.
My aspiration to become a judge of the High Court did not see the light of day due to various considerations for over 10 years. I was eventually appointed as a judge of the Federal High Court in 2012. Providence may have been at work in my eventual appointment to the bench, and I think it probably was a sign of divine approval for my selfless efforts in the defense of the poor. Reminiscing over my time in active service, I took my judicial duties with the highest sense of responsibility. I believe that judging is a divine function, and that humans who are appointed to judge other people must do so with humility, circumspection, and divine guidance. Judges must be prayerful so they do not fall. I am a fiery advocate of human dignity, respect for women, gender, and equality. My court was known as a place where everyone is important, lawyers and litigants alike. Even as I did not suffer fools gladly, I remember with pride my landmark judgment in FHC LCS 1497 of 2017, which has just been mentioned by the Honorable Attorney General of Lagos State. It was a matter that involved the registered trustees of the Socio-Economic Rights and Accountability Project, SERAP, and the Attorney General of the Federation and Minister of Justice. There, I ordered the state that states should urgently institute appropriate legal action to challenge the legality of state laws permitting former governors who are eventually senators and ministers to enjoy retirement emoluments while drawing normal salaries and allowances in their new political office, and to identify those involved and seek full recovery of public funds from the former governors. Regrettably, the order is yet to be obeyed. I find it very disappointing that court orders are often not obeyed. If there's anything I wish to change, it is the impunity towards judicial decisions and the disrespect to the bench. I also feel saddened by the inadequate recognition of the work of judges, despite the high qualifications for appointment to the bench and the pitiable salaries of judges, which have remained static for several years. Lawyers by themselves can improve the legal profession. I frown at the total degeneration of professional ethics, such as lawyers abusing the dress code, and I admonish young lawyers who desire to go into litigation to take hard work seriously. There is no shortcut to success in the legal profession. Becoming a refined litigator is like gold passing through the furnace. You must not only be hardworking but also determined and diligent, attending to every matter with zealousness, utmost importance, and care. A lawyer should be seen as noble in appearance, in and out of court. Their speech, action, basic etiquette, respect for senior colleagues, and respect for the court should be the watchword for all lawyers appearing before the bench. Generally, in my judicial career, I interacted freely with counsel and the public. My relationship with counsel remains very cordial and friendly, even if I say so. However, I have it on record that it was only once that a counsel who could not distinguish between certain principles of law dragged me in a petition to the Nigerian Judicial Council, National Judicial Council, and the said petition was dismissed after due consideration. I am retiring ahead of my time because I had surgery to reset my right hand in October of 2022, which needed 6 months to heal. I had suffered this ailment since 2019, but continued with my job since being a judge in Nigeria requires significant writing. As one who enjoys writing, I could not imagine how to continue to serve as a judge without being able to write. This, coupled with my husband's encouragement, brought about the decision to retire from the bench. I have heard from sources that there are plans to increase the retirement age of judges. it is my humble submission that in the view of the circumstances prevailing in our country, retirement age for judges should remain at 65 years unless the government is ready to put in infrastructure in place to avoid long handwriting for judges, which in itself results in deterioration of the health of the judges. Apart from that, there should be in place mechanism to discourage frivolous litigation on the part of the lawyers and appropriate remuneration for the judges.
And just before we go, a recap of the top trending stories in the news.
We begin with the report that Justice Inyang Ekwo of the Federal High Court in Abuja has temporarily declined to hear an application by Senator Aisha Binani Dahiru seeking an order of court restraining the Independent National Electoral Commission (INEC) from invalidating her declaration as winner of the governorship election in Adamawa State. Binani had on Monday approached the court for leave to file an application for judicial review of the administrative decision of INEC made on April the 16th in respect to her declaration as winner of the governorship elections of Adamawa State. The ex parte application filed by her lawyers, Mohammed Sharif, asked the court to determine whether the Independent National Electoral Commission (INEC) can take any further steps on the declared governorship election results made by its resident electoral commissioner, Mr. Hudu Ari. However, when the ex parte was about to be moved, Justice Inyang Ekwo asked Binani's lawyer to first address him if his court has jurisdiction to entertain such matters. The judge subsequently gave Binani's counsel 3 days to file his address on the issue and fixed April the 26th for hearing of the ex parte application and the motion on whether the court has jurisdiction. The same Justice Inyang Ekwo has barred the People's Democratic Party, the PDP, from suspending or expelling members with alleged alliances to the governor of Rivers State, Nyesom Wike. These members had allegedly engaged in anti-party activities masterminded by the Rivers State governor, who is a key member of the G5 governors. Delivering judgments, Justice Ekwo said the fears of these PDP members that they will likely be suspended have been well established, and their expulsion will amount to a breach of their rights to freedom of association. The judge therefore stated that it is in power of the court to grant redress to persons who have established actions that amount to rights infringement, as in the present case. The same court has also reinstated Mr. Ifeanyi Ararume as the non-executive chairman of the Nigerian National Petroleum Company Limited, NNPCL. The court voided his sack and set aside the removal done on January the 17th, 2022 by President Muhammadu Buhari on the ground that the action was unlawful and illegal. Delivering judgment in the suit instituted by Mr. Ararume, Justice Ekwo awarded the sum of 5 billion naira against President Buhari and the NNPCL to be paid to Mr. Ararume as damages for his wrongful sack. Justice Ekwo agreed that under Section 63 of the Companies and Allied Matters Act, the President is vested with powers to remove directors of the organization, but held that the powers were not at large. Another judge, Justice Hamza Muazu of the Federal Capital Territory High Court, has refused to vacate an interim order restraining the national chairman of the Labour Party, Mr. Julius Abure, the National Secretary Farouk Ibrahim, and 2 others from parading themselves as leaders of the party. Counsel to Abure had asked the court to vacate the interim order and restore a semblance of sanity after a takeover of the Labour Party National Secretariat by another faction. The senior lawyer said the division in the party following the interim order has worsened to the point that 4 groups in the Imo State chapter of the Labour Party held parallel primaries. Justice Muazu, by way of intervention, however, ordered all parties in the suit to ensure speedy filing of their processes for speedy hearing of the case. And we round off at the National Industrial Court sitting in Lagos, where members of the Road Transport Employers Association of Nigeria in the state besieged the court in their numbers to witness the proceedings in their case challenging the state government. Police officials were also on ground to keep the peace. In her judgment, Justice Esowe nullified the appointment of an ad hoc committee put in place by Governor Babajide Sanwo-Olu to run the affairs of the Road Transport Employers Association of Nigeria in the state and reinstated the elected leadership of the union. Justice Esowe also held that the act of the Lagos State government in suspending the national union's operations in the state and setting up a caretaker committee is illegal and unconstitutional. The court also restrained the state government from further interfering with the operations of the union excos.
And that's our program this week. Thank you very much for watching. Be sure to catch the repeats on air or watch via our YouTube channel. I'm Shola Shoyele. See you next week.